Merchant cash advances. They promise quick capital for struggling businesses, but they often create more problems than they solve, with effective annual percentage rates frequently exceeding 50% and sometimes reaching 400% and beyond. These products can push viable businesses into insolvency. Today we'll examine how Chapter 11 bankruptcy can provide a suite of legal tools to address MCA-related financial distress. I'm Joe Shapiro, a partner at Middlebrook Shapiro Law Firm. We represent clients in bankruptcy and litigation matters, and we provide strategies for businesses, business owners, accountants, and attorneys who are dealing with complex financial restructuring issues. Today we're analyzing merchant cash advances, their legal structure, why they frequently lead to business distress, and how Chapter 11 bankruptcy's statutory framework can provide a suite of tools to fight back. Here at Middlebrook Shapiro, almost every small business bankruptcy case that we file involves at least one merchant cash advance creditor. MCAs are increasingly the primary source of financial distress for our small business clients. And MCA collection actions are often the tipping point that drives our clients into bankruptcy protection. A merchant cash advance is not a traditional loan. It's marketed as a purchase of a business's future receivables. A business gets fast cash today in exchange for a cut of its future revenues. It's effectively a payday loan for businesses. This legal structure allows MCA providers to avoid traditional lending regulations and interest rate caps. And the catch is that businesses must make daily or weekly payments to the MCA companies, plus sky-high interest, fees, and costs. So once a business takes one of these MCA products, it's often forced to take another one just to pay the first one. This is the stacking effect, and then this is arguably just part of MCA business. And it creates a cycle of debt, which is almost impossible to escape. Once a business defaults, it's hit with UCC levies and a mountain of attorney's fees from all the MC creditors all at once. Courts and state authorities are taking notice of all of this. For example, in January 2025, New York Attorney General Letitia James announced an over $1 billion settlement with Yellowstone Capital. It's the largest consumer settlement in New York Attorney General history, excluding multi-state settlements, and it automatically canceled more than $500 million of outstanding debts owed by over 18,000 small businesses nationwide. So the lawsuit revealed that Yellowstone's MCAs carried an effective annual rate of as high as 820%, and that's more than 50 times New York State's legal interest rate of limit of 16%. Yellowstone had to make over $16 million of restitution payments, and all of they're permanently barred and banned from the MCA industry. So let's talk about the components of an MCA. The first is a factor rate, typically ranging from 1.1 to 1.5, which determines the total repayment amount. So for example, a $50,000 cash advance MCA with a 1.3 factor rate, you multiply 50,000 times 1.3, you get a $65,000 repayment. So while that appears, I guess, arguably reasonable, given the context of a business needing cash, really what you're talking about is 30% to 100% to a 400% APR. The second thing you're looking at is a holdback rate, and that's usually 10 to 20% of daily credit card sales. A business agrees to have that swept on a daily or weekly basis. This payment structure creates immediate cash flow pressures. So unlike a monthly loan payment, the business must remit daily payments, and this creates constant operational constraints. The third is the stacking process we talked about before, where a business ends up taking multiple MCAs in rapid kind of succession, and this compounds the burden on the small business and their owner, who almost always personally guarantees every single MCA loan. This all creates a vicious cycle, which really expedites a business's failure rate. And again, business owners having to personally guarantee these debts adds direct stress on the business and their owner, and threatens the business's owner's own personal finances. So now, Chapter 11 provides a strategy to address these situations. Once we file a Chapter 11 bankruptcy for a business, that whole cycle, that vicious cycle, must immediately stop. We then go to the bankruptcy court immediately and ask the bankruptcy court to look at the nature, amount, and priority of these MCA claims, and perhaps recharacterize them. We also ask for immediate use of the business's cash so that it can operate with some breathing room through the Chapter 11 case. So we automatically get the automatic stay by filing a bankruptcy, which stops the daily and monthly withdrawals, and it stops any collection actions that an MCA company may or has already put into place, including lawsuits. And the business is then protected, and the MCA companies must come to bankruptcy court. And they're subject to the jurisdiction of the bankruptcy court. And they have to follow the automatic stay. They have to abide by it. Otherwise, they can get in trouble by the court. So the main issue we address in Chapter 11 is the use of cash collateral. That's the business's use of its own cash moving forward. But remember, an MCA loan has already essentially liened that future cash. And as a result, there's a conflict and a tension. But generally, the bankruptcy court will let the struggling business use its cash moving forward. So we use this immediate first day motion, we call it, to allow the business to use its cash, which was already levied or liened under the UCC by MCA companies or was threatened to be levied. The Chapter 11 process itself then gives us an ability to holistically look at all of these debts and consider, are they unsecured, are they secured, and over the long term, how are we going to pay them through the Chapter 11 plan, which can go up to 5 years. Are we going to pay it at little or no interest, quarterly payments perhaps? And all of that's going to be based on a case-by-case basis, based on the struggling business's projected disposable income. And so in practice, the Chapter 11 case really lets us carefully analyze the structure of the sale itself. Is this MCA legit? Or is it a disguised loan in violation of the usury laws, as mentioned earlier, that was found in New York? We can look at the character and structure and amount of each of these loans and address them accordingly. We can also consider whether any of the money that was paid by the company in a certain time frame before the bankruptcy needs to come back. These are avoidance actions, they're called, preference actions. And there could be substantial recoveries that we can bring money back in, then we can reuse it to have the business restructure and pay other debts, perhaps taxes, and perhaps other things that have a higher priority. And then we can, in the Chapter 11 plan, which we're looking to confirm down the road, permanently make a settlement that all the parties have to follow. It's a confirmed Chapter 11 plan of reorganization. And that will give us a solid footing to ensure the viability of the business moving forward. So again, the Chapter 11 gives us these tools, the automatic stay, use of cash collateral, motion practices, looking at the objecting to the claim or considering recharacterizing the claim, and then permanently setting a payment plan that the business can follow into the future. So for attorneys, if you're representing businesses in distress, or accountants, if you're consulting with them, you might want to consider early on in the process, when you first start seeing these signs, considering how to integrate Chapter 11 potentially into your strategy. It's definitely advisable to consider it earlier on rather than proceeding down the path of litigation, which can be costly and can lead to adverse results. So if you'd like a consultation about these different bankruptcy strategies I just described, or if you want to work as a team with the business's professionals, here at Middlebrook Shapiro, we work collectively with the small business and its professionals to consider whether this strategy is right for the business. So this video itself is intended for informational purposes only. It should not be considered legal advice. It does not create an attorney-client relationship, and every situation is unique. You should talk with a qualified bankruptcy attorney about any of the matters we just discussed in this video. So thank you. If you got value from this video, please like and subscribe.